Ladies and gentlemen, welcome to It's Rainmaking Time. This is Kim Greenhouse. We have another heavy hitter on the show today. The man you are about to meet has been a constitutional attorney practicing constitutional law for 50 years. That's 50, ladies and gentlemen. He has practiced, written, taught, litigated about the Constitution and constitutional law. His entire professional life has been devoted to this very subject. He is a marvelous teacher, also giving an online course for people that are interested. He is an author and was seminal in the writing of the first gold clause that ever was. He is an author of so many books, but the one we want to talk about today is the gold clause, what is it, and how to use it profitably. Ladies and gentlemen, welcome Henry Mark Holzer to It's Rainmaking Time. Welcome, sir.
Glad to be here.
Well, I think the first thing you have to know is that I didn't know about you prior to interviewing Edwin Vieira. And he had spoken very highly of your book, even though he has published his own book and about you. And so I went to look you up, and when I went to your site, the site was so robust and your background was so thick in the Constitution that I thought we better start talking about this, and I was very excited about your class. Talk about your class for a moment.
Well, I decided not long ago, particularly after the advent of all these Tea Party groups and so much talk about constitutional law, that unfortunately most lay people, including patriots like the people in the Tea Party movement, don't know very much, if anything, about American constitutional law, except anecdotally. You know, Miranda rights are bad, and the interstate commerce clause has been twisted all out of proportion. That's not enough if you're going to fight for this country and fight for the Constitution. You need to know more. So what I've done is I've designed a course, which I am giving live beginning this Sunday for 10 consecutive Sundays, 2 hours about constitutional law, and I'm doing that live so that I can get it recorded, and that's all sold out, by the way. But beginning probably next Wednesday and every Wednesday after the Sunday when I do it live, it will be up on my website, and you have to promise not to laugh. I'm going to charge the grand sum of $2.50 per hour, which means that each 2-hour lecture is going to cost somebody $5 to download it. And my reason, I have several reasons for that, but not the least of which is that it's symbolic. In other words, people have to be willing to belly up and spend $5 to hear me talk about American constitutional law for 2 hours. I've concluded, unfortunately, that what people get for free, they tend to disvalue. And
I agree with you.
Not take seriously. On the other hand, I want to make it available virtually for free to everybody in this country who's interested in listening to it. And I compromised between $1,000 an hour, which is what lawyers charge, and zero at $2.50. So there you have it. If anybody wants information about it, I suggest what they do is next Wednesday, go on to my website, which is henrymarkholzer.com.
Spell it, would you?
Yeah, it's HenryMarkholz, like zebra, .com, and then just push the button that says Constitutional Law Courses, and it'll take them exactly where they need to go, and then they can buy it, just by pushing a button. It's I must say, I'm very excited about it for at least two reasons. One is the content, and by the way, on that website will be the entire syllabus for the 10 lectures. And it's very exciting material. And the other reason, of course, is that I'm going to pitch it to a lay level. In other words, it's not like I'm going to be talking to lawyers, let alone constitutional lawyers. I'm going to be talking to lay people, men and women who want a serious understanding of the basic principles behind, well, even the Declaration of Independence, the Constitution, and the Bill of Rights.
I think that's extraordinary. Absolutely extraordinary, because I think we're too far removed from it in day-to-day society now with our cell phones and computers and telephones and TV sets. We're just in other worlds.
Well, the beauty of the way this is set up is that if somebody does go on the website, they can download the lectures onto anything. I'm not 12 years old, so I don't understand all of the gizmos that are out there, like Blackberries and Blueberries and iPods and MP3s and all of that. But I'm told by knowledgeable 12-year-olds that if somebody goes to my website, they will be able to download all of these lectures onto whatever gizmo they like.
That's fabulous.
And listen to it anywhere, in a car at the beach and even in a movie theater if you don't like the show.
Why is it important now more than ever? Or why does it feel like it's important now more than ever?
Well, it's not just that it feels like, but it is more important because people are in the streets, at least figuratively, if not literally yet, fighting for this country. There are millions of them all over the country, and I don't mean to disparage them, but the fact is they are not armed. I mean, they are, from an intellectual, I can't quickly think of an apt metaphor or analogy, but I mean, they're in there with their bare hands fighting against people, not just politicians, but intellectuals on the left, and the media and the school systems and everybody else. They're fighting with their bare hands against these people who have very heavy weapons. And the people that are fighting, the Tea Party people and everybody else, need to be armed, and that's what I'm trying to do. I mean, you take, for example, just to pick a case out of the air, Roe v. Wade. There are a lot of people rightly against the law, if you will, in quotes, that came out of Roe v. Wade, an abortion on demand, essentially. And they oppose it on religious grounds, they oppose it on various other kind of grounds. But what they don't know is that the genesis of the seeds of Roe v. Wade are found in a case called Griswold against Connecticut back in the 60s. And Griswold dealt with a Connecticut statute that a state statute that prevented, believe it or not, the use of contraceptives in a marital relationship. Well, whether that's a good law or bad law is irrelevant. It's a bad law, and as one of the justices characterized it, even a silly law. But Justice Douglas, in a 3-page opinion, concocted out of smoke and mirrors a so-called right of privacy. Now, where did he find that? And these are his words. In emanations from penumbras.
What is that?
Emanations, vibrations, I guess, not to make a pun. Emanations from penumbras, which are kind of peripheral things, in some of the Bill of Rights provisions. For example, he had the temerity to say that the Third Amendment, which nobody ever talks about, dealing with not being able to quarter soldiers in private homes in times of peace, which was an issue in Revolutionary days, bespeaks of privacy. Okay? The Fourth Amendment, which deals with search and seizure, you need a warrant, bespeaks of, in his words, privacy. And he went through all of the various amendments and the subdivisions of the amendments, and he spun this web, all of which to him added up that the Bill of Rights is really concerned with, quote, privacy. And somehow that concept is applicable to contraceptive use in a marital relationship. Now, what he would do about people who fornicate on the beach, I don't know.